until the passage of the Statute of Westminster, no Dominion legislature had the power to pass either laws with normal extraterritorial effect or laws purporting to amend or repeal imperial laws which expressly or necessarily applied to it. The need for this change was demonstrated in 1925 when the Australian High Court had ruled inoperative sections of an Australian Commonwealth Act which contradicted provisions of the Imperial Merchant Shipping Act. 15. Section 2 of the Statute of Westminster is perhaps the most significant legal provision relating to Canada's acquisition of legislative sovereignty, because it accorded both Parliament and the provincial legislatures the power to pass any laws amending or repealing legislation of the Imperial Parliament. Also, no Canadian law passed thereafter could be held void because it conflicted with imperial legislation. 16. Even if the Imperial Parliament passed a bill against the wish of a Canadian government, it could be repealed by the local legislature. However, none of these provisions related to the British North America ACTs. This exclusion had been made at the request of a Dominion Provincial Conference in 1931, because the Canadian First Ministers could not agree on a method to amend the Constitution themselves. Section 3 of the statute also gave the Dominion Parliament full power to make laws of extraterritorial operation, but this provision did not apply to provincial legislatures, and they still lack this general power. 17. In 1933, the Canadian Parliament passed an act which provided that all federal ACTs already in force would have the extraterritorial force they would have had if passed after the Statute of Westminster, 18(6). These provisions giving all Canadian legislatures the ability to amend or repeal imperial legislation and the Canadian Parliament the power to pass extraterritorial laws form the foundation of Canada's acquisition of legislative independence. The transition between the former legislative regime and that prevailing after 1931 is reflected in a 1933 court case dealing with the Canada Shipping Act. This act was declared inoperative because it had been passed prior to the Statute of Westminster and had not received the formal approval of the British government required under the UK Merchant Shipping Act. 19. The following year the Canadian Parliament replaced the inoperative Canada Shipping Act and repealed all the British ACTs dealing with Canadian shipping. Conventions supporting the Statute of Westminster. Law in that Dominion. The final legal step was achieved in 1982 with the passage of the Canada Act, which contained another rule of construction declaring that no future British Act would have effect in Canada. Furthermore, the power of the British Parliament to amend the formal Constitution of Canada was passed to a new legislative authority vested in the Governor-General, who can now proclaim amendments when authorised by a varying number of provincial legislatures and Parliament. 39. However, conventional rules have continued to play a crucial role in enlarging and protecting these legal provisions. First, a convention required that Dominion consent actually be sought and given to British legislation applying to the Dominions. Secondly, the unilateral British repeal of the provisions of the Statute of Westminster, or the Canada Act has been barred by a fundamental convention protecting the independence of Canada and the other Dominions. There is no doubt that this convention would be upheld in substance, if not in name, by Canadian courts.